All right, boys and girls, welcome back. Saturday edition of Freedom Steel. Todd Vandermind here, former NRA contract lobbyist and Illinois gun law guru. So the hits just keep on coming to the anti-gunners. Late yesterday, we got a decision out of Oklahoma. District Court judge striking down Section 922G3, which is prohibiting possession of firearms by people who use marijuana. I'll have a whole separate video on that. And earlier in the week, we had a case out of the Fifth Circuit Court of Appeals. The Court of Appeals is actually based out of New Orleans, but this looks to have been a Texas case, and it's called Riani. And this case sits there and goes on to find that Section 922G8, which deals with people possessing firearms who are under civil orders of restraint, restraining orders based on domestic violence stuff, that section is unconstitutional. So let's get into the meat and potatoes of this. So Section 922G8 says, it shall be unlawful for any person who is subject to a court order that A, was issued after a hearing of which such person received actual notice and at which such person had an opportunity to participate. B, restrain such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person, or engaging in other conduct that would place the intimate partner in reasonable fear of bodily injury or to the partner or child. And C, includes a finding that such person represents a credible threat to a physical safety of such an intimate partner or child, or two, by terms explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury to, possesses in, or affect in commerce any firearm or ammunition. So there you have it. It is one of the questions that is on the 4473. And with that, issues about this, this is not a DV conviction. This is not somebody who has been convicted in a court of law. And in the decision, they made a distinction about that, saying that the distinction between a criminal and civil proceeding is important because criminal proceedings have afforded the accused substantial protections throughout our nation's history. In crafting the Bill of Rights, the founders were plainly attuned to preservation of these protections. See the Constitution Amendment 4, Constitution Amendment 5, U.S. Constitution Amendment 6, U.S. Constitution Amendment 8. Is therefore significant that 922G8 works to eliminate Second Amendment rights of individuals subject merely to a civil process. And people are going to go, okay, yeah, well, this has implications around the country and here in Illinois. So this is not a criminal conviction, just as that footnote 6 noted in this decision. And this is a decision by a court of appeals. It's not the district court. So this individual, who is a bad dude, he is an outright douche canoe. This guy is just a number one dirtbag. And there are a whole host of reasons he shouldn't have a gun. But they charged him on a federal charge under 922G8 for this civil order, this restraining order. And he challenged it. And he challenged it prior to Bruin and lost. And what's significant here is that the Court of Appeals sat there post-New York, post-Bruin. I hate Bruin. It ought to be New York, but everybody's calling it Bruin these days. I'm slipping into that. But he challenged it again and said, hey, wait a minute. The standard has changed. And they vacated his criminal conviction, finding that 922G8 is unconstitutional. This is a civil order. So if you remember, not too long ago, we had a case that we analyzed, Atkinson, in the Seventh Circuit Court of Appeals. That order, the decision in that case has not come down yet. But I'm going to bet that they become aware of this decision because there was a lot of the same rulemaking. There was a lot of the same analysis in the orals there as to what went on and what the period of time is about long-standing. And if you remember, right out of the gate, 20 seconds into the state's case in chief, the chief judge just started ripping on the lawyer from DOJ that, this is not long-standing, and they're right. And this other case in Oklahoma that we'll do a separate analysis of really drives that point home. So you've got that, which is here in Illinois, which is going to set some stuff up. You also have the Range case in the 3rd District in Pennsylvania. Court of Appeals found that the felon in possession statute for nonviolent felons was legit. And then not long after, the entire court, the en banc panel, decided to vacate that decision of the 3-judge panel, and they are going to rehear that case in a matter of weeks. So this decision has come out now, and I think this decision, because a lot of the stuff that has been argued is being torn apart. The federal government seems to be arguing the same cases where you can keep guns out of the hands of Catholics, guns out of the hands of slaves, and claiming those. And this Oklahoma case, not this case, the Oklahoma case, really tears those apart. We'll get into that, again, like I said, in another video. But this has a really big impact here in Illinois on 3 issues. We haven't talked a lot about them, but one of the issues is our red flag laws. Red flag laws being a civil proceeding. And in the first part, it can be done ex parte. You don't even get the opportunity to sit there and show up and defend yourself. This thing, they let they let your mother-in-law or somebody else go in there and make all kinds of specious arguments. So if you're going through a nasty divorce and your father-in-law just doesn't like you, he can go in there and make all kinds of claims without you getting a chance to represent yourself. They come, they take the guns, and then they ask questions later. This seems to fly in the very face of that, since that is a civil proceeding. It's not a criminal proceeding. Next, there's been a challenge to our clear and present danger standard contained within the FOID card. Again, this isn't even a judicial proceeding where there's a judge making a determination. This is a determination made by the state police, all and of themselves. A law enforcement agency can file a report making a claim of a clear and present danger, and without a judge, the state police can rule on this. This is what got the state police all bent over in the Highland Park case. Highland Park Police Department made a claim of a clear and present danger. The Highland Park shooter did not have a FOID card. The state police did not hang on to that for any length of time. And then the guy got a FOID card, and the state police were left holding the bag. They took the brunt of the blame. So what have they done? They have expanded the clear and present danger claims on what goes on. They have now allowed clear and present danger claims to be filed prior to anybody getting a FOID card, and they will be hanging on to them for what looks like to be a minimum of 5 years. And then they will define clear and present danger, and then you have to go to court to prove you're innocent, to prove your case. That seems to fly in the face of what this Court of Appeals in the 5th District has just said about civil restraining orders on for domestic violence reasons. The other issue that nobody's been talking about came in light to me because of a case that was brought to my attention where an individual got charged for a simple battery at a bowling alley. It is not a charge that, even if convicted, you become a prohibited person. But as a condition of bail, most of the courts around the state have this condition. As a condition of bail, you will not possess or have firearms. Wait a minute. You've only been charged, you haven't been convicted, and you may not have even been in front of a judge. This is just you bailing yourself out at the police department. And because of that, that gets put into a system, and with more and more records being electronic, the state police are then revoking FOID cards based as a condition of bail. Again, there's no criminal conviction, and even if they were convicted of a simple battery, a simple assault, if they don't have any DV components to them, they are not prohibited conduct. It's not conduct that's going to get you that's going to cost you your right to keep and bear arms, your right to own a gun under state law or federal law. And then if you take it to its end, if you end up, say you get a DUI, same thing, condition of bail, no firearms. You get convicted, but in light of a true conviction, they sit there and say, hey, what we're going to do is we're going to give you a suspended sentence, and if you complete your terms of supervision adequately, then you will have this expunged from your record. It'll be like conviction never happened. And they're saying that as a condition of your supervision, you can't own or possess firearms. Bullshit. According to this ruling, they can't do that. Now, this is the Fifth Circuit in the Federal District, not to be confused with the 5th District in Southern Illinois in our state circuit court system. So this doesn't necessarily apply to Illinois yet, but the basis, the reasoning, the logic, the legal thinking behind this is all solid ground in light of New York. And so here you are. This case is going to start to rock the boat and go through. This is where things are starting to hit. Rubber's hitting the road with New York. We had this case come out. We have 3 cases in New Jersey where the judges have said, nope, in light of New York, not getting this. You've got 2 cases in Colorado. This stuff, the dam is about to break on this stuff. Judges all across this country are taking New York to heart. They are getting it. They are understanding it. The judge, like that one up in Washington or Oregon, it was Measure 114. She looks to be the outlier these days. So, good news here, guys. This is something that's going to be rolling around here for a little while. So, with that, I wanted to give you an update about this. Got to try to crank out a few more videos that will be popping out over the next day or so. Trying to get caught up here. I've been tied up working on Illinois litigation here and challenges to the semi-auto ban and things that are going on there. So as always, please like, subscribe, hit the notification bell so you know when we've got new content coming out. Keep copying and pasting this link in all your social media. We really, really appreciate it. We're getting up there in our subscriber count. And we really appreciate all the support with everybody. And as always, frag out.